I would like to call this April 9th, 2015 Board of Adjustment meeting to order. Roll call, please.
Cameron Tabor.
Present.
Teresa Dozier.
Present.
Michael Painter. David Palmer.
Present.
Vivian Simpson.
Present.
Donna McLeod.
Present.
Shay Balance.
Present.
Are there any changes to the agenda?
No, ma'am, no changes.
Okay. And do we need a motion for
Motion to approve the agenda.
that? Second.
I'll second.
All in favor say aye.
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 All opposed say no. Okay. Motion carries. Is there anyone wishing to speak to the case who is not an applicant? Please sign in and indicate which case. I believe everyone's signed in. I already have the list here. Does anyone on the board wish to disqualify themselves for any case to be heard tonight? Okay. I will announce that we have a quorum tonight with 4 regular members and 2 alternate members. And I would like Donna McLeod, please, to sit through the cases tonight. And Shay, you are excused.
Thank
you. We do need to approve the minutes.
I make a motion that we approve the minutes of the last meeting, the March meeting.
I second the motion.
All in favor say aye.
Aye.
All opposed say no. Motion carries. We've got old business and new business, but okay. Is there any old business?
No, ma'am.
Okay, and is there any new business? Just the 2 agenda items before us?
Yes, ma'am.
Okay.
Item 4 and item 5.
So we will move on to item 4, BOA 1502. Andrea Sherman, is that correct?
That's correct.
Appeal of a notice of violation that an accessory structure was placed on the property that exceeds the allowable 100 square feet located at 135 Inlet Lane, Walnut Island, Tax Map 107B, Block JJ, Parcel 18, Section 5, Poplar Branch, Mainland Township. And we'll hear from our board secretary first, the staff, and then we'll ask others to speak.
Ms. Sherman, you'll have an opportunity to speak, and you'll have an opportunity to ask questions of the staff.
I don't think his
who
mic is
speak
on.
under oath after they have their opportunity to present their case, ma'am. And people do need to be sworn. Madam
Yes.
Chair.
Everyone who signed in, please come forward and we'll do the swearing in right now.
Ms. Sherman, you need to be sworn in to testify on the case. This is just for the Sherman case. If you're not for the next one. One at a time.
You want to swear in for me too?
Hold it in your left. Raise your right hand.
Oh, I wasn't thinking that was me. Forgive me.
I swear to tell the whole truth, nothing but the
Which
truth.
page is it on, Stacy?
First page.
Do you swear to tell the whole truth and nothing but the truth?
I do.
Yes.
Okay.
Thank you, Madam Chair. And the case before you is an appeal to the notice of violation that was sent to Ms. Sherman, the property owner of 135 Inlet Lane in Walnut Island, that an accessory structure was placed on the property that exceeds the allowable 100 square foot. Within an existing camper subdivision, the UDO allows for one structure, accessory structure, not to exceed the 100 square foot may be permitted on a camper lot. I just want to briefly go over a little background with you. You have all this in your packets, so I won't go through everything. Basically, the county received a complaint regarding a structure being placed on this property without proper permits. On July 29th, 2014, Jason Corbell, our building inspector, who is here with us tonight to answer any questions, investigated the complaint and posted a stop work order on the property for a building that was built without permits, after which time the contractor continued to work without permits. On August 6, 2014, Mr. Corbell sent a certified letter to Ms. Sherman advising her to stop all work and to come into the office and to obtain county permits. After the receipt of this notice, Ms. Sherman came into the office and spoke with Mr. Corbell and myself about the structure. We went over in detail with her that the structure cannot exceed 100 square feet allowed in the camper section for an accessory structure, at which time she advised us that it was a camper. We discussed with her in reference to that it doesn't meet the camper ordinance. And our camper is designed as stated in our UDO, a portable dwelling as a special equipped trailer or automobile vehicle for use during casual travel and camping. Mr. Corbell stated that she could potentially turn this into a single-family dwelling as long as she met the minimum building code. So after speaking with her, we went back out there and we noticed that there was a travel trailer tag posted onto the structure. We contacted the sheriff's office who ran the plates, and it belonged to a 1999 Prowler trailer. It didn't fit the description, so of course at that time we contacted Mr. Bateman, Roy Bateman, who is an inspector with the North Carolina License and Theft Bureau, and requesting his assistance on this case. We had some email correspondence back with him, and he stated that this unit was not a vehicle, that the such structure was purchased at the state line in Grandy. After our investigation, staff determined basically that the structure was not a camper, and it exceeded the allowable accessory structure size of 100 square feet, and therefore a notice of violation was sent on February 5th, 2015, advising Ms. Sherman to either, 1, remove the building from the property or have it properly permitted as a single-family dwelling. To date, the structure is still located on the property at 135 Inlet Lane without proper county permits. And with that, I'll be happy to answer any zoning questions you may have. And Jason Corbell, our building inspector, is here tonight to answer any building-related questions you may have in reference to the structure.
Thank you.
Just so I'm clear, that building is not necessarily illegal, it's just not been permitted? Is that where we are?
Actually, the building, 1, does not have proper permits. It can go two ways. If she wants to use it as an accessory structure, it has to be less than 100 square feet in order to meet the UDO's requirement for a camper lot. If she is going to turn it into a single-family dwelling and meet the minimum building requirements, then she would need to obtain proper permits from the county for a single-family dwelling.
Thank you.
Are there any other questions for staff? It's at the bottom. There you go.
As a single-family dwelling, it requires certain things like plumbing and that sort of thing. Is that right?
I'm going to get Jason Corbell, our building inspector, to go over that with you. Okay. I am not a building inspector, so I can't answer. We work together on this case.
Okay.
Mr. Corbell?
Yes, minimum plumbing is required. You got to have sanitary. You got to have bathroom, which has a sink, a commode, and a tub or shower. You also have to have a kitchen with a sink.
And does this building have any of those?
At this time, no, ma'am.
Okay, thank you.
Is there any, I mean, if she were to apply for those permits, is there anything that would keep her from meeting all of that criteria? I mean, is that a lot that it could be, that it could actually be met?
As far as zoning requirements, we have, as long as it contains an independent cooking, sleeping facilities, and sanitation facilities, it would have to meet the minimum lot coverage, 5 feet on the side, 10 on the front, and some CAMA because it is on the water. So we have to think about our Coastal Area Management Act that we handle for the state. So she will have to go through the CAMA permitting process. And then, of course, she'll have to meet the minimum, with the building inspector.
Is there even enough room for a septic system?
I believe they are sewer district in the camper section.
Okay. Okay. Any further questions for staff?
Jason, do you recall the square footage of this building?
Before I came up, I counted the joists that were underneath it and figured it up that way, and came up with it's 12 by 32, which is 384 square feet.
Very well, thank you.
Yeah.
You'll want to give Ms. Sherman a chance to question staff as well.
Okay. And Ms. Sherman, do you have any questions for staff?
Yes, I do.
You're welcome to come forward. Just take your time. Please state your name again at the microphone.
Hit me. Andree Sherman.
Thank you.
I bought this piece of land in 2013. There was nothing but a hovel on there. Two days ago, I received this. What I'm allowed to put on there, to their specifications. That is a camper trailer. It has a 1999 base on it. I've seen what you... allow being put. As you can tell, I'm upset. I was told I could not tie it down, which with 45-mile-an-hour winds, you can't get away with that. Even 60-mile-an-hour winds. Here is one that was allowed in 6 years ago.
Ms. Sherman, we'll gladly let you submit anything you want, but you cannot have it back. It becomes part of this. Is that correct, Ms. Smith? Okay.
Can she show it? Can she just show it to us and take it back?
We can make copies for her after the meeting.
Does that look any different?
Madam Chair?
Pass it to Ms. McLeod.
Any different than what?
Than the one I have.
Okay.
Oh, it's got a steel roof.
I understand that. What is your point with that, please?
The point is, I told everybody what I was putting in there. 1 bedroom, 1 bath, a pantry, and that was it. And it was built for me. Just the way I wanted it.
Where did you have a camper trailer built?
On 17 North. On 17 North.
So if you choose, this could be pulled behind a truck.
Oh, yeah. That's the way it came in there.
Did it come on it?
But
Did it come on a truck or pulled by a truck?
It was pulled.
It was pulled on wheels?
Pulled it with my car.
So am I to assume the wheels were removed after it was bought in?
That's what happened. I wasn't here, they removed them, laid them down, and then I had to pay to have them put it back up again.
So State Line Builders built that building on,
Oh, 17 North.
okay, they built it on wheels. It was built on wheels, is that right? Or some sort of frame containing wheels?
Yeah, they're still there. I got pictures of that too. You want that?
Oh, it might be nice for us to see that, how it looked before the wheels came off. And my question, as a camper, does it still not have to meet certain requirements?
Yes, hold on one second. Let me.
And a camper is described as a vehicle, is that correct?
Yes. As our UDO states in the definitions of a camper is a portable dwelling as a special equipped trailer or automobile vehicle for use during casual travel or camping. And that's the definition of a camper. Basically, when you have a camper, you have a title for such camper. Also, in the same section of the UDO under non-conforming campgrounds, there's general standards for your campers and your campgrounds. Basically, one of the general standards is campers may not be modified in any manner that would render the unit non-transportable. So as you see, she's removed the wheels. Even if she has the wheels back on, it's blocked up underneath and it's not transportable. Basically, they're temporary units that can be moved on and off and taken to campground after campground, and they would need to be ready to move at any time, licensed and road ready.
So is your intent to have it as a movable camper or a single-family dwelling?
I can move it any time.
The wheels are gone, so
No, the wheels are on there.
they're still there?
Yeah.
But do you intend to have it closed in underneath?
Well, in order to get it insured, you have to have it tied down and you have to have it underpinned.
So then doesn't meet county requirements that way for a camper. Is that understood? Am I understanding it correctly?
Yes, ma'am, it needs to be portable. It cannot be modified or enclosed in, and no additions to campers are permitted.
Stacy, at any point, could this actually, with a lot of work, of course, be turned into an acceptable single-family home?
It would meet all the zoning requirements as long as she meets the setbacks. I think Jason spoke earlier, the building inspector, in reference to as long as it has the portable sanitation, the minimum sizing, it could meet it. Of course, at that point, it would need to be taken off its wheels. Am I understanding right? And have a foundation, just like any single-family dwelling would do. We changed the ordinance under the new UDO in January of 2013, allowing for single-family dwellings in these camper lots. So we have reduced the setbacks to allow for such things.
So the short answer is yes.
Yes.
Thank you.
Yes, but Ms. Sherman, you're not leaving yet, are you? We're not finished with the hearing.
I understand you are, but we're not.
I guess there's nothing that says you can't.
Yeah.
That you could certainly leave if you would like to, and you'll be notified by mail of the decisions.
You would have no more say-so if you left. You understand that?
I'm giving all the proof I can give.
Well, yes, ma'am, but we're not. You asked us to be here, and we would like for you to be here as well. Please. I've got a question for you.
Would you please come back up to the microphone, Mrs. Sherman?
May I speak, Madam Chair?
Sure.
Ms. Sherman, would you be opposed, or what is your opposition to this being built as a single-family home per the county ordinance? I understand you want to call it a camper, but that doesn't necessarily make it a camper. With all due respect, I just want to get clear in my head what you're hoping to accomplish here.
I
Take your
spent
time.
over $50,000 on this place. And that I want it to be my home. Okay.
Mrs. Sherman, are you opposed, as you were asked? To making it a single-family dwelling?
Well, what would that entail?
Jason can explain that for you.
Would you do that for us? I think we went over it, but I think now would be appropriate.
In order for it to be considered a single-family dwelling, it will have to have sanitation, meet the minimum room sizes, and it has to be on a permanent foundation. There's different ways of getting the permanent foundation because it's in a flood zone. It has to be elevated. So it's either putting it on blocks this high with pier curtain wall or putting it on pylons 8 feet in the ground. The foundation would need to be designed by an engineer because the home itself was, my understanding, built by a state line and set on a trailer frame. So they would need to have it designed by a professional engineer.
Thank you.
Thank you.
Does the board have any other questions for staff?
I have a question. Is there someone within our county that could help her and guide her on what she needs to do to get this right? So she has, because it seems this is what she wants to make. It's her house.
Well, Ms. McLeod, there is, I believe the building and planning department can do that, but we need to decide on whether or not to uphold the county's decision on this matter.
Does anybody else have anything to say?
So are there any other questions for staff? And we can have discussion now. Can we close the session and then we'll have discussion and vote on this?
I don't see how this is a camper. I've tried and tried. That's kind of where I am right now. It's just as much as we may try, it's just not a camper.
I agree. It doesn't appear that you could put it behind a big, it would take at least a 350, maybe more, to pull this thing.
Well, you wouldn't.
So,
pull it far,
I mean, you couldn't drive it around to different campgrounds and camp in it.
If I may, one thing that may get you headed in the narrowest possible direction is if you look at attachment 5 and look at what the actual violation described is, and just read that and make a determination. To what they said there was a building was placed on the property that exceeds the allowable 100 square feet, and one accessory structure not to exceed 100 square feet may be permitted on a camper lot, provided it complies with the dimensional standards. So if you make the decision that it's not a camper that would otherwise be allowed there, then essentially you're deciding that it is an accessory structure, and then you make the consideration of whether or not it's more than 100 square feet, and you could look at this decision that they made, that the staff made, and then you would either affirm it or reverse it or modify it. And I pointed you to that because I think there's been a number of things about the building code and about sanitation and other issues that are well beyond the actual violation that was noticed.
So we're going to address the violation.
Mm-hmm. Unless there's any other discussion.
Is there?
Yeah, is there any other discussion from the board?
No, but I would bring forward a motion that we uphold the administrator's decision and the county's position that this is not a trailer, that it is a building placed on the lot. The findings of fact as presented support that, and as I said, I move that we approve and support the county's position.
Do I have a second?
I'll second that motion.
All in favor say aye.
Aye.
All opposed say no. Motion carries. Okay, item number 5 on our agenda tonight, BOA 1504, David Knoch, is that correct?
Correct.
Appeal of the planning director's decision that a single-family dwelling located at 599 Laughing Gull Court, Currituck Club, tax map 117A, parcel 129, Poplar Branch Beach Township, complies with the Currituck County Unified Development Ordinance. And we'll hear from staff now first. We need to swear in, excuse me. Please state your name in the microphone. Thank you.
Ben, want to start? Ben Woody, Planning Director.
Dave Knoch.
Jeff Maloney with Twitty and Company.
Greg Wills, attorney for the property owners.
Okay. And do you swear to tell the truth and nothing but the truth?
I do.
Okay.
Could I ask one thing for clarification? Mr. Wills, you said you're attorney for the property owners?
I am the attorney for, it's actually C3 Outer Banks LLC, which is the title owner of the property that's shown on this picture. That is the
okay, for the owners of this
subject matter
property, not for a property owners association.
No, sir.
Okay,
No, sir.
that's all.
I'm the attorney. Mr. Raffelli is the individual member of the LLC, and I'm representing him in the LLC, which is the title owner of the property.
Very good. Thank you.
Yes, sir.
Ready?
I'm ready, Mr. Woody. Thank you.
Madam Chairman, this is a request. Actually, this is an appeal of an interpretation. So let me kind of get you from where we came to how we got to here. Mr. Knoch approached staff last year and asked or felt like that the property at 599 Laughing Gull Court was not being used as a single-family dwelling, but rather was being used as an event house or something similar to a hotel or a motel. At that point, staff advised Mr. Knoch that the appropriate course of action would be to ask the planning department for an interpretation. An interpretation is a process in which the staff, if there's some sort of indecision or question or some kind of lack of understanding of what an ordinance provision means or what the zoning map means, the staff's empowered to interpret that. Now, what the staff does is we effectively take the language, the intent statements, and we interpret that to the extent to which we think the legislative body intended that ordinance to be. So what I'm saying is the staff doesn't make the rules. We essentially interpret what we think the intent of the elected officials, in this case the Board of Commissioners, was with the ordinance part in question. So that's what we're here tonight, is the staff is interpreting the ordinance in regard to the question asked by Mr. Knoch, which I'll cover in more detail in a second. Once the interpretation is issued by the staff, we issued that back to Mr. Knoch. He requested it. We also provided a copy of that to the property owner because obviously they have a vested interest in it because they own the property. At that point, the next step is then Mr. Knoch, if he agrees, or if either party disagree with the interpretation, they can then appeal it. And that's what's before you tonight, is an appeal of the staff's original interpretation. And of course, the appeal then goes to you, and then your job is to consider the information provided by staff and the interpretation and the testimony you hear tonight from both parties. Then, of course, what you're going to do is make a decision on the appeal, which again is an interpretation of the legislative intent of the Board of Commissioners. So that's the context for kind of where we're moving forward tonight. So I'm going to dive into this directly. The interpretation alleges that the subject property, again, on the aerial photograph, you can see where it's located. This obviously was taken before the structure was built. This is in the Currituck Club subdivision, which is over on the Outer Banks. If you're not familiar, there's a Harris Teeter shopping center on the Outer Banks, and the Currituck Club is a private community located behind that Harris Teeter. So it's on the west side of NC 12. The interpretation filed by Mr. Knoch alleges that this property is used as an event house and is more like a bed and breakfast or hotel than a residential home. In support of this interpretation, Mr. Knoch also provided 12 exhibits. Those 12 exhibits are in your agenda packet. They're labeled as such. I'm not going to cover each of those in detail, as I'm sure you've already reviewed those. But Mr. Knoch is here, and I'm sure he will speak to each of those exhibits for your benefit tonight. I'll summarize. Generally, Mr. Knoch is alleged that the subject property is advertised as a special event for weddings, provides food prep areas for caterers, is large in size and scale compared to other single-family dwellings, and creates significant parking issues within the Currituck Club subdivision. What staff then did is, upon receiving the interpretation, is we initiated a review. We want to take everything very seriously, so we reviewed the information submitted by Mr. Knoch, and in part of that, we also, at that point, we emailed the property owner to let them know that Mr. Knoch had requested this interpretation of the use of their property. In a subsequent telephone conversation with Mr. Wills, who's the representative of the property owner, on January 8th of 2015, the staff asked the owners to clarify in writing their use of the property. So we gave the property owner a chance to respond to the allegations made by Mr. Knoch. That response was provided by Mr. Wills on January 27th, 2015. That response is also in your agenda packet. You can see the letter following Mr. Knoch's information. Again, I'm not going to speak to that in detail. Mr. Wills is here, and he'll certainly cover that tonight for your benefit. What staff then did is after receiving the information from both parties, we then reviewed the permit records for this subject property. The permit records indicate a zoning compliance permit for a single-family detached dwelling was issued for this property on March 14th, 2013. Subsequently, the structure was built after the permit was issued. A residential certificate of occupancy was issued on April 8th, 2014. So approximately a little over a year later, the CO was issued. The building plans and the site plan that was submitted for the structure show that the property contained one principal structure that contained not more than one dwelling unit and was not physically attached to any other principal structure, which is consistent with the Unified Development Ordinance's definition of a single-family detached dwelling. And therefore, on the face of this, the county issued a permit for a single-family dwelling under a UDO, and the subject property, based on that, was not constructed or intended to function as a hotel, motel, or bed and breakfast. And hence, that's why the permit was issued and the CO issued by the county. And really what the interpretation, and to get into that a little more, the request references the property as an event house that accommodates in special events and weddings, and that's probably the crux of this discussion tonight. And again, we're interpreting this in the context of the Unified Development Ordinance. We'll first say that the UDO does not define an event house. There's not a thing in the UDO. It doesn't exist, so there's no definition to go to for event house in our zoning ordinance. So what that does is then the county has to assess, this particular property, how it's constructed, how it's used, and how does that fit in the ordinance. And the construct we have is, does it fit in the ordinance as a single-family dwelling, or does it fit in the ordinance more as a hotel, motel, or bed and breakfast. In evaluating that, and I want to get into context of the Outer Banks, many of the single-family detached dwellings in the county are in fact intended for rental at a week at a time, and that's one thing about this property I'll note. It is in the rental program. It is rented weekly. During the course of those weeks, there probably are events that happen, perhaps a wedding, perhaps whatever it may be, a family reunion. But regardless of the size and scale of any structure, the fact is that in Currituck County, single-family dwellings are built and permitted and oftentimes are rented for a week at a time. And as you are probably aware, the week-long rental of properties of single-family dwellings is permitted in North Carolina, and as a matter of fact, the General Assembly of North Carolina codified a section of the General Statutes, Section 42A, called the Vacation Rental Act, which actually allows or promotes or establishes that, in fact, you can take your house and rent it for a week in North Carolina. So in that sense, we think that particular management of a house is no different than any of the other houses on the Outer Banks, and that, in fact, is quite common. Well, note in Currituck County, we kind of went and said, well, what is this? How many of the houses in Currituck County, in fact, are rented weekly? And we actually found that then, according to the 2010 census, there are 4,591 housing units in Currituck County that are for seasonal, recreational, or occasional use. The census data illustrate that the use of single-family detached dwellings is allowed under the Vacation Rental Act is really common practice in Currituck County. And I say all that to say that I think by the mere fact, staff's opinion, that the house being rented for a week in and of itself isn't anything unusual and doesn't deviate it from being a single-family detached dwelling. And I guess we would say further along that the fact that during the course of these weeks that probably many of these properties are rented for half a day or for half a day or for several hours during one of the days. They may have a wedding, they may have a special event, but again, in and of itself, staff's opinion is that isn't enough to say that these structures are hotels, motels, or bed and breakfast. I think what would distinguish a hotel or motel is the fact that when you rent there, you rent an individual room, you rent it for one night, there's a lobby, there's a check-in, there's things that exist in those kind of daily rentals that you just don't see in the houses in Currituck County and the Outer Banks and the way they're managed. So when staff got into this and we applied, we interpreted the UDO, we felt like ultimately the board's intent was that no matter the size of a structure, because the UDO doesn't distinguish, the UDO doesn't say you can't have any size structure. There's no limit on bedrooms, there's no limit on square footage, so we felt like size wasn't something that was really a determining factor. When you get back to use, we didn't find evidence that the house is used as in a manner similar to a hotel, motel, or bed and breakfast, and in that sense, we didn't find the house is used different than many of the other houses in the area on the Outer Banks. The other part of the interpretation, or the other part that Mr. Knoch brings up is impacts. So big house impacts such as noise and overflow parking. The UDO, like I said earlier, doesn't have standards on bedrooms and square footage, but the UDO does have standards on noise and parking. So we acknowledge the fact that, yes, there are parking that needs to be met and there are noise requirements. The extent to which these ordinances are effective is really not germane to your interpretation tonight. Again, you're interpreting, is this property used as a single-family dwelling as defined by the UDO, or is this property used as some other use such as a hotel or motel? If there are parking issues and there's noise issues, then perhaps number one is the county needs to enforce their ordinances better, or perhaps if the ordinances aren't effective, then the Board of Commissioners needs to take legislative action to improve the ordinances. So again, I would say when you get into this, what we're looking at tonight is use and not necessarily the effectiveness of another ordinance related to parking or noise. While those are certainly important issues, I just want to give the context of how staff looked at those. So essentially, because of the reasons I've covered in the presentation tonight and the reasons outlined in the letter of determination in your packet, the Planning Department feels like that the property at 599 Laughing Gull Court is used in a manner consistent with the zoning compliance permit that was issued for the property on March 14th, 2013 for a single-family detached dwelling. And that concludes my presentation, and I can answer any questions you have.
Does the board have any questions for staff?
Yes, I do. if you don't mind.
Yeah, go ahead.
But first, I'd like to ask a few questions of Mr. Gallup before I go to Mr. Woody. Mr. Gallup, could you please make clear for us and for the audience the charges that this board has in interpreting and possibly overturning a administrator's decision? Have I asked it clearly enough?
Clearly, but very broadly. I think you, from a simple perspective, you sit in the chair, the same shoes and seat as the staff members who reviewed it initially, and you can affirm, reverse, or modify in whole or in part their decision. And in this case, the decision is the interpretation that was provided to Mr. Knoch?
Yeah.
At his request. That is their decision. So what is being appealed is the correctness of that decision.
Mr. Knoch is appealing Mr. Woody's decision that this is, in fact, a single-family structure.
Correct.
Okay. And we have the power to affirm Mr. Woody's decision, overturn his decision, or modify the decision.
Yes, if you take into account the facts that you hear tonight and analyze the law, you can do any of those three things.
Okay. Further. Now, Mr. Woody, if I could ask you, the code 42A that you spoke of, when was that codified?
That was codified in 1999. Now, it's been amended subsequently since 1999, but that was when the Vacation Rental Act was established.
In any of the amendments, was size and number of rooms addressed?
Not to my knowledge, no, sir.
Okay. In 1999, do you know roughly the average size of the beach houses that we were developing on the Outer Banks?
I do not. I could give you an anecdotal answer. I can certainly say they were smaller in 1999, but I can't give you a specific number.
Okay. Okay.
Any other questions for staff from the board?
Mr. Woody,
Yes, sir.
if we could visit original intent, was it seems to me in reading the UDO, the original intent, even not so much back in 1999, but the most recent interpretation or deviate, whatever the most recent time that the Board of Commissioners visited this ordinance, it seems to me that their intent was to not allow hotels. Are you willing to address that? I mean,
Do you mean so?
and if you think I'm asking your opinion,
Do you mean their intent in terms of in a residential zoning district? Their intent wasn't to allow hotels.
yes.
I think their intent is not to allow hotels in a residential zoning district.
Thank you.
Any other questions for staff? Okay. Anyone?
You'll want to give Mr. Knoch and I assume Mr. Mallarney is here as a witness, not as an attorney tonight, and
Right.
Mr. Wills is here as an attorney for the property owner. You'll want to give Mr. Knoch and Mr. Wills both an opportunity to ask Mr.
That was
Woody
what I
any
was gonna
questions that
do.
they have.
Mhm.
And Mr. Wills has been through this a number of times, and for Mr. Knoch's understanding, you'll have an opportunity to question, and then once the staff is done with its presentation, you'll have an opportunity to put on your presentation, and Mr. Wills and I suppose Mr. Woody, since Mr. McCree's not here, will have an opportunity to question you, and then Mr. Wills can put on, and if he has any evidence, and you and Mr. Woody will have a chance to question his witnesses. So it's for the folks who have not been here before or who are new to this, it's very much like a court proceeding. There are essentially three different parties. The county is one party, the owner is another party, and the applicant who is appealing is another party, and everyone gets an opportunity to question each other's witnesses that speak under oath.
So we'll have David Knoch next to ask staff questions. Please approach the microphone and state your name, please.
I had a few notes here, but Ben threw me off, I guess. My name's Dave Knoch, and I'm a resident of the Currituck Club. And I guess I was going to originally let you know that I've owned property here in in Currituck County for 36 years. So I'm just not a fly-by-night person. I'm one of you, okay? And I've lived in the Currituck Club for 16 years. My claim to fame is that I'm the first year-round resident. So back in 1999, when you were asking Ben what size houses were there, I guess you can say mine was one of the first, and it was basically a 4-bedroom house, okay? There was 2 other houses being built across the street, custom houses. They were like a 5-bedroom and 2 5-bedrooms. And then there were some homes down in Magnolia Bay, which is a subsection, and they were 3 and 4 bedrooms. So basically, we didn't have any large facilities in our community, okay? And that's not to say that we didn't migrate up some, okay? You know, next, there's a house behind me that has 6, maybe 7 bedrooms, okay? And I just felt that this was an extraordinary large facility. I'm not calling it a home or a residence because it's not. Ben interpreted it that way, but Ben looked from I said, Ben, I think you have blinders on like a horse. You're looking at it straight from a UDO standpoint. My friend over here, the attorney, looked at it from the vacation rental, whatever it's called, Vacation Rental Act, okay? Everybody's looking at it that way. And all I have been trying to do is to get people to look at it from how it was designed, how it's being promoted, and how it's being utilized. And it's not like anything else in our community. Okay? And then Ben, in his little speech or presentation, says, well, yeah, there's probably a wedding going on, half day or, an hour wedding. Okay. That's just a small part of what's happening there. You all aren't living there. Ben's not living there. These gentlemen aren't living there. I am living there. And I have a golf cart, and I'm driving around seeing what's happening. And I'm just trying to relate it to you. Anybody that's had children get married recently? I have, so I'm not against weddings at the beach. Please, don't take me against weddings. Both my sons, and Ben knows one of them for sure, have been married at the beach. Small weddings, okay? One was married over on the Sound side, and one was married on the ocean front, okay? Small weddings. Everything at the Black Stallion facility is large, noisy, and of duration, okay? And when I'm saying, okay, your wedding's only a half hour maybe, where the preacher stands up there, but the events at this place go on the entire week. It's rented, okay? You have the bridesmaids luncheon or party, the bachelor parties there before, the reception the Friday night before the wedding, okay, the rehearsal dinner. Everything is going on at this facility. Everything. It's a conference center. It's designed that way. It was built that way. It's been advertised that way, promoted that way, and is happening that way, and it's every week.
Mr. Knoch?
Yes.
Please excuse me, but do you have any questions for staff?
Okay. I disagree with you, Ben, and the reason being is you're not looking at it it's happening out there. You're looking at it how it was put in, how it was permitted, and not what's happening. And that's my basic argument and disagreement with my good buddy Ben.
And Mr. Knoch, it may be worth you staying up now.
Okay.
You've essentially gone to your testimony stand of it. And
I sure
and
have.
If I could
Now,
just
we may have questions for you now.
Yeah.
All right.
If I could have a brief second to ask
apologize.
Mr. Woody, are we done with staff's presentation?
Staff has concluded their presentation.
Thank you.
Mr. Wills, did you have any questions for Mr. Woody?
No, not for Mr. Woody. I do have some comments about sort of the scope of what we're doing, but I can reserve that and make those comments when it's time for me to ask questions and submit testimony.
But you don't have any questions for Mr. Woody?
Woody, no.
Okay, and so now we'll assume that Mr. Knoch has just testified, and Mr. Woody, do you have any questions? Or
We have
let's
one
ask-
other,
let's
Mr.
ask-
Mallarney. Does he get to speak to staff?
He will.
Okay, that's
Mr.
fine.
Mallarney is Mr. Will's witness.
Okay, thank you.
So
Yeah,
so
2 against 1.
So I think probably the best thing is to ask if anybody on the board has any questions for Mr. Knoch, and then go to Mr. Woody, and then go to Mr. Wills.
I had one other point, since that, I guess, what was my presentation. The other issue that I would be concerned with, if I were on your side, okay, is the safety issue, okay, and the zoning issue. And I've talked to the fire marshal and the fire chief, and they have shared their concerns with me. And what I think the whole process is driven is by the dollars. Everything's driven in this world by dollars, okay? And you see these other large facilities going up, and they want to call them residential versus commercial. Now, why do they want to do that? Many reasons. But it all gets back to money. Insurance, okay? Building cost. Let's think about this. If that facility there was commercial, think of, we'd have an exit sign there. We'd have handicap things. We'd have sprinkler system. But since they're residential, they don't have to put them there. But with 48 people there, don't you think it would behoove the county to zone it in a commercial manner? So from a safety standpoint, we have all that. So that was the last point I was trying to make. And I thank you. And if
Does the board have any questions for Mr. Knoch?
I do.
Yes.
Is that what is the outcome you'd like to see? It become commercial?
Okay. What I'd like to see is what I did initially. And the one point I did not make is I attempted and did what I thought this gentleman or the owner of the lot should have done, is have a piece of property rezoned appropriately. 13 years ago, my wife and I wanted to do a bed and breakfast in the club, in the Currituck Club. And we worked with the developer to have a lot that was down in Magnolia Bay, zone BB1. We went through all the proper channels, had all the postings, had all the hearings, and it was zone BB1. And my wife and I owned a lot, and we were planning to build a bed and breakfast. She became disabled. She's disabled now, and our dream fell apart, and we ended up selling that home site. But anytime I believe you don't have a residence and you have a facility like this, you need to do it the appropriate way and have it zoned appropriately and let the people around you know what's happening. And this never got done at this facility. That facility The gentleman that built it knew what their intent was. They have the flooring in their garage. I don't have to tell you what it looks like. You've got pictures of it. They've got a catering kitchen. It was designed from the concept to be a hotel event center. And that's what it is.
Excuse me, but would you like to have it rezoned? Is that what you're saying?
Right.
Would that resolve the noise issues?
My intent is to ask you to close down the facility because it's improperly zoned and require him to go through a rezoning to commercial and have everybody have the opportunity to say, no, we don't want you in our neighborhood as a hotel motel. And that's what I want. I did it when I wanted to build a bed and breakfast, and I felt like this gentleman or whoever the owners is should have done the same thing. And that's my reasoning for being up here. Okay? It's just correct and it's the right thing to do in a neighborhood.
Thank you.
Any other questions of me?
Any other questions from the board? Okay, thank you, Mr. Knoch.
But Mr.
Oh,
Mr. Wills.
Yes.
And both of
Would
you
you
need to,
come back to the microphone and, Mr. Wills, please state your name?
My name is Greg Wills.
Thank you.
I'm the attorney for Mr. Raffelli, the homeowner. And just a couple of quick questions, I hope, Mr. Knoch. First off, when did you build your home?
1998.
Okay, and do you own...
Excuse me, Mr. Knoch, would you mind coming a little closer to that microphone?
1998?
Thank you.
And do you own lot number 86 in the Currituck Club?
Yes, sir.
I'd like to show you a document, if I could. Would you
That's me?
take a look at that?
Yep.
Does that kind of show your lot in relation to, we'll call it the Black Stallion lot?
Yes, correct.
Very good.
Can we,
I'm
Mr.
going
Woody,
to
can we
get
get a
some
copy of
copies
that?
and have that admitted into evidence. Just a moment, I got another picture. Again, Mr. Knoch, this is just an aerial photograph, pretty much showing the same thing. Would you agree that that blue area depicts where your home is in relation to the Black Stallion lot over
Correct.
here? And so you're just off, is it
Golfview and Hunting Club.
Gulfview, the intersection of Gulfview and Hunting Club Road?
Hunting Club.
Okay. If it's okay, I'll mark these as, I guess, defendants exhibits 1 and 2, and I've got copies for the members of the board as well.
that's fine. Just make sure everybody gets one and that,
All right.
that staff gets one to put in the record.
Couple
One
other
of each to
questions,
put in the record.
Mr. Knoch. When you built your home in 1997,
98.
98?
Yeah, I think we moved in June of 98.
and the Currituck Club has a property owners association, correct?
That's correct.
And when you submitted and before you built your home, you had to take your plans to the Architectural Review Committee for the Currituck Club, correct?
That's correct.
Okay. And to your knowledge, is that the same thing that Mr. Raffelli had to do to construct his house?
Yes, but with a little difference. At that time, it was more run by the developer, okay? And so he had a whole lot of say, and now it's basically 5 owners or 3 or 4 owners that are on the architectural. So it's a little different makeup, but basically the same.
So the Homeowners Association has a committee designed to review plans, and you have to go through that process before you can construct your house within your subdivision. You
Right.
agree?
Right.
And you had to do it?
Yep.
And as you know, the covenants require anyone who builds a house in the Currituck Club has to do it, right?
Right.
Okay.
You're moving towards a point here, I think.
I would just offer these as exhibits 1 and 2 and into evidence, and those are all the questions I have for Mr. Knoch.
You would, if there's no objection, then you would accept the exhibits and the evidence.
Okay. Is there any objection from the board that we accept those as evidence? Do we need to vote on that? Okay.
The
Then
chairman
we
gets
will.
to decide
Okay.
to accept it.
We will accept that.
Thank you.
Just want to look at it. Okay. And Mr. Maloney.
You may want to ask Mr. Knoch if he has any other witnesses to bring forward.
Do you have any other witnesses, Mr. Knoch, that you would like to bring forward?
Didn't bring a support team. Kind of here supporting the neighborhood. And gentleman showed you that I don't live right beside the house. I live a couple blocks away, which is on the map. But I feel close to the people who live on that particular block, and they have supplied me with significant information that was in the package, pictures of the vehicles and so forth. So I'm representing a group of people in the Currituck Club.
Are you representing the homeowners association?
No, ma'am.
Okay. And your other neighbors did not want to make that
No,
themselves?
the majority of them are second homeowners and don't live year-round like I do.
Thank you.
And now you want to ask Mr. Wills if he has anyone.
And Mr. Wills, would you like to bring anyone else forward to testify?
Yes, ma'am. Very briefly, I'd like to call Mr. Jeff Maloney as a witness and just ask him a few questions, if I may.
Okay.
First off, Ms. Maloney, go ahead and tell the members of the board about Twitty Real Estate, what you do, and what you know with regard to the home that's the subject matter here.
Sure. So Jeff Maloney, I've been with Twitty & Company for the last 12 years. Twitty & Company manages approximately 1,000 homes in Currituck and Dare County. It's a vacation rental management property company that's governed and regulated by the North Carolina Real Estate Commission and Chapter 42A, as Mr. Woody pointed out. And we manage, as the agent, vacation rental homes to vacationers. We are not, I think, in the hotel or motel business in any manner whatsoever, or the bed and breakfast. It's strictly weekly rentals to vacationers on the Outer Banks.
Mr. Maloney, did you see the letter that Mr. Woody was referencing that I had written to him in regard to the interpretation being requested here?
I believe I have previously.
And did you see attached to that in the packet of materials that are already before the members, there was copies of a rental management contract and the vacation rental contract for the specific homeowners? Did you have a chance to review those?
I have.
And are those true and accurate copies of the contract that you have with the homeowner to act as the rental manager? Second, are those copies within their packet of materials of the contracts which Twitty requires all homeowners who rent the home to sign or execute before they're allowed into the home?
Sure. So just a 30,000-foot view of the vacation rental industry on the Outer Banks. Agents are required, like Twitty & Company or Sun Realty or Corolla Classics or anybody, to enter into agency agreements with owners to manage their property. Once you've entered into a contract to manage an owner's property, then the property is leased by the week pursuant to Chapter 42A Vacation Rental Act. So for each week that's rented on the Outer Banks, a lease is executed by the tenant and the owner vis-a-vis the agent, which is the property manager in this case, would be Twitty & Company.
Okay. Does Twitty & Company rent individual rooms in these houses, or does a tenant have to rent the entire house for the entire week?
It's a weekly rental. There's no nightly rentals. And in Twitty & Company's case, we don't even rent partial weeks. We only rent weeks that are 7 days in length. That makes a little bit redundant, but...
And does the contract that Twitty has with the individual homeowner affirmatively prohibit them from subleasing or trying to rent a room once they've rented it from your company?
That is correct. And each, is I'm familiar with it, every Vacation Rental Act lease with every tenant doesn't allow subletting or assigning of the week.
And does the contract that you have with each tenant specifically mandate and require them to comply with zoning ordinances and the covenants for the individual home and limit it strictly to residential use.
That is correct.
And if any of those tenants violate that current contract, can they be evicted? And do you have the authority by virtue of the contract entered between you and the homeowner to evict those tenants on an expedited process?
For certain types of violations, there are an expedited eviction under Chapter 42A. And of course, Mr. Woody and the county has the ability to enforce its zoning ordinances or criminal misdemeanors, that sort of thing, or parking violations.
And when you become aware of these things on behalf of the homeowner, complaints, whether it be noise ordinance violations or parking issues, do you as the rental manager, or does your company as the rental manager attempt to intervene and manage and supervise these things as they come up?
We do on a case-by-case basis. Of course, we don't have the ability to enforce parking violations, only the county does. Or if there is a disturbance and that sort of thing, the sheriff's department's called. Otherwise, we do intervene, in the management of the home to the extent that we're allowed to under 42A.
And does the way that this home, despite the size of the home, is the practical mechanics of renting it differ at all from the way that Twitty would rent, we'll call it a 3-bedroom or a 4-bedroom or an 8-bedroom home? Is it substantially the same process?
No, I would suggest that almost all homes on the Outer Banks that are vacation rental homes are marketed in a similar manner. They're placed on the website for consumers to evaluate. They're in rental brochures. They're in different magazines, publications. The tourism bureaus, both in Currituck and Dare, promote vacation rental homes individually and collectively. This is no different other than in the size of the home. And it's, in fact, not the largest home. It's just a large home.
And so are there, to your knowledge, are there other homes in the Twitty rental management program within the Currituck Club?
We, in fact, do not rent other homes in the Currituck Club. Other property management companies do.
But do their policies and procedures similarly?
They're all the same.
They're all the same? And every contract makes specific reference to the Vacation Rental Act, is that correct?
Every contract is the same. As Mr. Gallup knows and Mr. Wills knows, we attempt not to vary our lease in any manner whatsoever. And I think that's probably true of most vacation rental companies.
Thank you. I don't have any further questions.
Can we allow Mr. Knoch to ask some questions? He was raising his hand.
He not only allow, but he has a right.
Okay, and so if you would like to come forward, then you can ask the questions that you wanted to.
You may want to caution him to ask questions, given that his presentation time was past.
All right.
So if you have questions,
a question. All right.
Ask of Mr. Maloney, and make sure that the microphone picks up both of your voices, please.
My question of you is, and you say that in your contract, and I worked for Village Realty for a time in the rental side, and I worked for Kitty Hawk Land, and I sold property here in the Currituck Club. So, and I had my real estate license, so I'm somewhat familiar with all this. They're not supposed to sub-rent or rent out rooms, right?
Who is not?
The people who lease the house from you. That's correct.
Pursuant to our contract, they're prohibited. That's correct.
All right. But I provided Ben with 2 examples of people attempting to sub-rent rooms there. In your package was a piece of information of a group up in the Williamsburg area doing it. And then in another email I sent to Ben was a wedding party that was wanting to get money for the rooms. All right. When you're spending $25,000 for a house, Dad's going to pay for all of it? Oh, you all have got more money than I do, so if I'm renting it for my daughter and all these friends come down, don't you think I'm going to try to get a little out of there? So how many times has this place been rented, and how many times do we not know?
Excuse me one moment. Mr. Chairman, I would call a point of order. He's supposed to be asking questions at this
All
point.
right, so I'm just saying that I brought to your attention that it's been sub-rented or attempted to. And Ben can validate that for me. Thank you.
Are there any questions from the board for Mr. Wills or Mr. Malarney?
I'd like to make one follow-up point on the question that he asked. Mr. Malarney, Mr. Knoch was just referencing a senior advocate travel club brochure that is contained in the packet of materials that the board already has.
It's page 47 of your packet, so it's towards the back.
Which purports to rent this home actually this week, April 6th through 11th of 2015, and it purports to have a per room, per person, reservation process. Could you tell the members of the board what investigation and what you know about that specific allegation?
We were actually unaware of that, and it's just fraudulent. I don't know how to summarize it any more succinctly, but from time to time, this is the first time in my 12 years in 250,000 leases that run across my desk that I've seen a nightly rental that's advertised. From time to time, we'll come across folks that will scrape the vacation rental management sites from Korea or Russia, that sort of thing, and then try to rebrand and essentially scam consumers. And so this was a new twist this very year. Just happened to be coincidentally with this home. I've never seen this before, and it's fraudulent.
And if the person who rented this home during this week, well, first off, is anyone doing what is purported to happening here at the Black Stallion as we sit here today?
Not that I'm aware of.
And if anyone were to attempt to do this, would that violate the provisions of the rental contract that you have with the tenant prohibiting them from subleasing the property?
Yes, it would.
And would they be summarily evicted?
That is correct. We'd be forced to file a civil action if that did, in fact, take place. And we would.
Those are the questions.
Any further questions from the board?
Mr. Rafali, there's been...
That's
Mr. Malarney.
Malarney.
I represent Mr.
That's right, I've been called worse.
You'll excuse me for that. Were you there when this building was prior to its being built?
Was I employed by Twitty & Company prior to this home? Yes, sir.
Were you with Twitty & Company and you were part of this process from, let's say, from the time the first shovel hit the ground?
Well, I'm the general counsel for Twitty & Company, so I'm not necessarily involved in the process of...
Well, what I'm driving at here...
Yes, sir.
It was brought up, Mr. Woody's determination of being permitted or not. And this board has been brought to our attention, and we've had cases where a house of this nature was being built, and we determined, this board did most recently, probably in the past year, that yes, it met the UDO requirement, but it was presented to us as if it were a person's home and it would be rented out occasionally. And part of what I'm doing is defending Mr. Woody because what he said was exactly right.
I believe so as well.
But he does not have the latitude this board has. And like I say, it's been brought to our attention when this has been contested before that this was going to be a home and they were going to rent it out once in a while, which is done all over the Outer Banks and places all over the country. But do you know that that was the case when this was being built?
I assume so, in my role, but it's no different than any other house that we represent. You know, there's 1,000 homes that folks come to vacation rental managers like Tweeting Company or Beach or, you know, Village, it doesn't matter, that sign contracts with agents to enter into vacation rental agreements with vacationers.
Well, maybe I didn't ask the question right.
I apologize if I didn't answer.
No, maybe I didn't ask you right. To me, it looks like the original intent was for this to be a rental property and was to be rented out as a rental property, we'll call it that, and was not the home that's been presented to us in the past. This was someone's beach home that they visit occasionally and enjoy, but they also rent it, and that's fine. Do you know that to be the case at all? That this was presented as being a personal beach home?
I'm not aware of the intent of, you know, or any of the intent of homeowners with regard to, you know, what they ultimately want to do other than rent it.
Mr.
for
Mallarney,
vacations.
you wouldn't have been aware of that until after it entered the rental program, correct?
Well, I mean, from time to time, you know, even picking up on your answer, homeowners do come to vacation rental management companies to discuss how is the home going to perform in the industry and the Currituck Outer Banks. And we provide projections if you were going to rent it. Now, what a homeowner does in electing, do they want to rent it for 2 weeks, 10 weeks?
Yeah, but you wouldn't know until it entered the program.
It's not
I
under.
obviously misunderstood your role. Thank you.
Yes, sir.
Are there any other questions from the board? And can we close this portion of the, do you have any questions?
I'd like to address a few matters to the board, if I might.
Okay.
Let me step down.
Yeah, if the board has no further questions or anyone has. I want to comment on what Mr. Gallup said in response to some of your questions about what the role of the board is and where we are. As Mr. Woody noted, my client did obtain a building permit for the home that he has. Everything, the sole issue that I think the board has to determine, and the sole thing that Mr. Woody had to determine, was whether or not the use as a vacation rental is in compliance with the UDO. I'm not here today prepared to defend the assertion that if I cannot use this home as a vacation rental, what sort of vested rights my clients may have. And so I did want to say that it does appear that the role of the board is to interpret or to affirm or deny the interpretation of the Uniform Development Ordinance as it is presently written and as interpreted by the staff. If the board were to determine that use as a vacation rental is not allowed for this property, then there would be a significant issue of my client's vested rights for the home, and I wanted to say that. And in response to Mr. Tabor's question about what was the intent of Mr. Raffelli could not be here today, but he did want me to convey to the board that he purchased and built this house. He's been coming to the Outer Banks for years. He has an extended family, and he used to rent 2 or 3 homes for his whole family. And he bought this lot back in 1995, and he and his wife intended to build a large home that they could have for their entire family. And he did design this home as the way that he wants it to be, in compliance with the UDO and the permitting process. It is a residential home. It is his home. And it is used, just like many, many homeowners on the Outer Banks, it has a dual function. It has an investment function, and placing a home into an active vacation rental is not violative of the UDO. And what Mr. Knoch is asserting in his testimony that what he wants is to change the zoning. Well, you can't change the zoning for a specific lot within a subdivision where the covenants for the subdivision mandate that it be residential use only. So I wanted to make that point of clarification that what Mr. Knoch purports as the solution is not something that can actually be done. And that our rights are certainly vested in terms of the use that we had because of the permits that my client obtained, and including the approval of the Property Owners Association for the construction of this home. And the narrow issue is whether or not its use as a vacation rental is consistent with the county's definition of single-family residential. That's what I wanted to say, and I want to thank you all very much. I'll answer any questions.
Are there any further questions? And Mr. Knoch, can he ask any other questions if he would like to?
If Mr. Knoch wants to have
if you have a question, you may ask. Okay.
I guess.
Would you approach the microphone, please?
My only question of you or Mr. Tavelli or whoever is that, and I know there's been questions throughout the entire process when he went in front of the Homeowners Association, said, this is a residence for me and my extended family, okay? Extended family, 48 people? Okay, that kind of blew my mind, but let's assume he has...
What is your question, Mr. Knoch?
That I don't think he was being truthful, okay, at that time. And I think his intent was to build a commercial facility. And that's my basis for my thing is that I feel like it needs to be rezoned because it is commercial and not residential as the owner says it is. So.
Thank you.
Thank you.
And we can close the public portion now. Oh, there is someone else on the list. Would you, Miss Betsy Daniel, would you like to speak to the case?
I am here because I got a letter as an adjoining property owner, just to get information. My undeveloped lot is directly adjacent to Mr. Rappiali.
If you would like to speak, you can come and state all of that at the microphone. If not, then, I mean, you don't have to, but if you'd like to, we'd like to have it on the at the microphone, please.
I don't need to speak.
Okay, thank you. Okay, that's everybody on the list. And we can close the public portion now, and the board will have a discussion and make a decision here. Are there any questions from the board?
I would say that similarly to the last one, what you really want to focus on affirming, modifying, or reversing is the final paragraph of the interpretation letter, which the rest of the paragraphs are the staff's support for reaching its conclusion, but its conclusion is that the use of the property is consistent with zoning compliant permit that was issued to it for a single-family detached dwelling. So that's the issue before you. And briefly, if I might, we've touched on the question of rezoning or not rezoning. Of course, this board can't do that.
That's not what our board
does. That's a legislative process for the Board of Commissioners. Additionally, if you were to find that the staff had interpreted this incorrectly, that wouldn't necessarily mean that the homeowners would have to stop immediately. They would have a right to appeal, and they could go to court and challenge that. And the final result of that decision might then result in the county taking some sort of enforcement action if it went that far. So the reason I put that forward is to let you know that what you're doing tonight is probably not going to solve Mr. Knoch's immediate desire to have the property stop functioning, however, completely, and to do any sort of rezoning. What it would do is potentially, if you ruled in favor of Mr. Knoch, would potentially set in motion things that might have that final outcome, but would not necessarily tonight.
So, Mr. Gallup, what you're saying is, if we were looking for a solution, okay, the solution would come legislatively more so than judicially.
I wouldn't say that more so. I would say that Mr. Knoch's perspective may be solved legislatively if it's not able to be solved through some other process. The legislative process could certainly have issues with solving an existing permitted residence, dealing with an existing permitted residence, but if it's a problem, if homes like this have determined to be a problem by the legislative body, there are ways for the legislative body to address it in the future. And on the same note, when interpreting the ordinance as it sits today, there were ways for them to address it at the time that they last amended the ordinance in this arena, and potentially them choosing to not do so may affect your decision of how to interpret the intent of that written word.
Mr. Gallup, the Board of Commissioners sit as the legislature for this, for the codes and the UDO and stuff.
Correct.
They're the ones that make the changes, and they interpret it to the current position. They're interpreting the code that was written in 1999 to have allowed where we are at this point.
Well,
when they chose not to change anything, they interpreted it to allow for what we now have.
I wouldn't say they interpreted it, but they didn't make a change that made any changes from what was there previously. So if it was allowed previously, then you as the interpreting, what you do is interpret the ordinance.
Correct.
And you as the interpreting body would be able to make the determination as if it was allowed previously, then it's allowed now if there weren't any changes to what was by the legislative body in the process.
And correct me if I'm wrong, this body does not set precedent.
That is correct. Well, let me say, it's correct with regard to individual cases and individual properties. It may make a decision that's made with regard to an individual property might affect a later decision with regard to that property, but with regard to other properties, different owners, different parties, that this board typically is not considered to be a precedent-setting board.
I think I asked the question wrong. I've been doing that a lot tonight. Thank you.
Are there any other questions?
Are we open for discussion at this point?
Yes. Yes.
I have to, I'm speaking to the board and to the public. I've followed this for quite a few years now, and not this particular house, but the growth in the industry. And the ordinance, the code is set, and it was put together in 1999. My feeling is that at that time, they never envisioned a 24-bedroom house. I do believe, though, that Mr. Woody interpreted the letter of the law, and that the people did perform due diligence. They went through the channels, and they have fulfilled the letter of the law. But I do not believe that was ever the intent of the law. I believe that the intent was to allow people to build houses and to rent them out, because building a beach house is terribly expensive. And many people want to visit the beach but don't want to have a house. At the time, and I'm going back and I shouldn't be testifying, I apologize. I just believe that when the code was put in, it did not envision the large houses. There are other municipalities up and down the coast that are dealing with this, and unfortunately I feel that as I said, Mr. Woody did follow the letter of the law, but I do believe that our commissioners have missed the intent of it, and I believe they need to readdress it. I don't see any resolution for the current property owner. I believe they did everything that they were supposed to do. It was open and above board as far as they submitted. There's plenty of time, long time ago, to address it before the first shovel got put in the ground. And to come in afterwards, and the commissioners would not be able to do spot zoning. It's not allowed. So to take a residential development and spot zone to commercial would be impossible, and that'd be open for another lawsuit. Unfortunately, I feel as though the administrator did follow the letter of the law, though in some way I wish we could put word to the commissioners that this needs to be addressed. It's being looked at in other communities. We need to preserve Currituck County.
Are there any other questions? The board's decision here tonight is to determine whether we will affirm the county's interpretation on this residence at David Knoch's request, or we will choose another route.
To reverse or to modify.
To reverse or to modify. If there are no other questions, do we have a motion?
I will stick my neck out and make a motion that we do overturn the administrator's decision on the grounds that it is not interpreting the intent of the 1999 ruling.
Motion's on the table. Do I have a second?
Motion fails.
Motion fails. Would someone else like to make a motion? I can't make it.
You can make a motion.
Okay, I will make a motion that we uphold the county's interpretation of this residence 599 Laughing Gull. The interpretation was requested by David Knoch. I have a second.
I'll second.
We have a second, a motion and a second. All in favor say aye.
Aye.
Aye. All opposed say no.
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 So it's 3-2.
Motion.
It's upheld.
Motion carries. Are there any announcements? If there are no announcements, do I have a motion that we adjourn?
I make a motion that we adjourn.
Second? All in favor say aye.
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 All opposed say no. Motion carries. Meeting adjourned.